If you are currently holding a green card and looking toward U.S. citizenship, or if you have already filed your N-400 application, you need to understand that the immigration landscape in the United States has entered a new era as of March 2026. Under the second Trump administration, the tone, structure, and enforcement philosophy of immigration policy has shifted dramatically. What we are witnessing is not a closure of the naturalization pathway, but rather a recalibration of the standards required to complete it. The emphasis has moved from efficiency and access towards scrutiny, vetting, and demonstrable civic alignment. In today's comprehensive masterclass, we are breaking down exactly what has changed at USCIS this month, how those changes affect lawful permanent residents, and what practical steps you must take to protect your application in this evolving environment. Let's begin with the most visible and immediate change: the full implementation of the 2025-2026 Naturalization Civics Test. As of March 2026, any applicant who filed their N-400 after October 20th, 2025 is no longer tested under the previous 100-question framework. Instead, applicants must now prepare from a 128-question bank. While at first glance that may seem like a modest expansion, the structural change inside the interview room is where the real shift has occurred. Under the previous format, officers would ask up to 10 questions, and the applicant needed to answer 6 correctly. Now, officers are authorized to ask up to 20 questions, and you must answer at least 12 correctly to pass. The passing ratio may appear mathematically similar, but psychologically and practically, this increases pressure during the oral interview. Applicants must sustain accuracy across a longer questioning sequence, and there is less room for recovery after early mistakes. Moreover, the substance of the test has evolved. Simple geography-based prompts such as identifying a state capital have been reduced. In their place, applicants are now expected to demonstrate deeper comprehension of constitutional structure, federalism principles, separation of powers, checks and balances, and the practical functions of each branch of government. Questions now probe more complex civic understanding rather than surface-level memorization. The administration has described this shift as ensuring robust civic preparedness. The underlying philosophy is clear. Citizenship is not simply a status change. It is a demonstration of intellectual and civic readiness. Beyond the civics test, one of the most consequential developments in March 2026 is the expansion of digital vetting, tied to the good moral character requirement. USCIS has formally implemented mandatory disclosure of social media handles used within the past 5 years. This is no longer a soft review. Officers now have structured authority to examine publicly available online activity, affiliation statements, and patterns of engagement. This does not mean that casual opinions automatically disqualify applicants. However, it does mean that digital presence is now part of your character profile. The administration's broader extreme vetting initiative aims to assess alignment with constitutional principles and loyalty to the framework of the United States government. During interviews, applicants may now face questions related to past public content if an officer believes clarification is required. This shift has already contributed to a measurable increase in requests for evidence, particularly in cases involving extended foreign travel, complex employment histories, or digital content requiring explanation. Applicants must understand that consistency between their oath of allegiance and their documented public activity is now under review. At the same time, despite heightened scrutiny, processing times in March 2026 remain surprisingly stable. In many jurisdictions, the median processing window remains between 5 and 8 months. USCIS has prioritized naturalization as a final stage benefit and continues to move cases efficiently through the pipeline. However, speed is now paired with strict completeness expectations. In prior years, minor document gaps or overlooked paperwork could often be resolved after the interview. In today's climate, we are seeing what immigration professionals describe as a precision standard. Applications that are incomplete at the time of adjudication are more likely to receive denials or extended delays rather than discretionary leniency. This is particularly significant in cases involving continuous residence. If you have spent more than 6 months outside the United States in a single trip, officers are now applying heavier scrutiny to determine whether residency was truly maintained. Proof of ongoing ties, such as mortgage statements, lease agreements, employment verification letters, active bank accounts, utility bills, and tax filings, may be requested to substantiate continuous residence. The burden of proof rests entirely on the applicant. Financial review is another area where March 2026 reflects a tightened standard. Tax compliance is no longer a background formality. Officers are reviewing IRS tax transcripts for the statutory period, typically 5 years, and applicants must be prepared to demonstrate full compliance. Any unresolved tax liability, payment plans, or discrepancies must be documented clearly. Financial independence is being emphasized as part of the administration's broader merit-based immigration philosophy. Additionally, selective service compliance is being revisited more consistently. Male applicants who resided in the United States between the ages of 18 and 26 must demonstrate proper registration or provide a credible explanation for failure to register. This requirement, though long-standing, is being enforced with renewed rigor. So what does all of this mean for you in practical terms? It means your N-400 application should be treated as a comprehensive legal presentation. Every date must be accurate. Every trip abroad must be logged precisely. Every employment period must align with your tax records. Inconsistencies that might previously have been overlooked are now more likely to generate follow-up questioning. Preparation must extend beyond civics memorization. It includes organizing physical copies of tax transcripts, confirming travel records through passport stamps and airline confirmations, ensuring selective service compliance if applicable, and reviewing your digital presence with awareness. For applicants over the age of 65 who have been permanent residents for 20 years, simplified civics testing remains in place. However, for the majority of applicants, the 128-question framework is now the operative standard. Outdated study guides from 2023 or 2024 are insufficient. Looking ahead through the remainder of 2026, the dominant theme of U.S. immigration policy appears to be integrity through enforcement. Naturalization ceremonies continue weekly across the country. Thousands are still becoming citizens. The pathway remains open, but the standard of review has undeniably intensified. The administration's position is that citizenship must reflect demonstrated commitment, lawful conduct, civic knowledge, and financial responsibility. Whether one agrees or disagrees with the policy philosophy, the operational reality is clear. Preparation and precision are now essential. If you have an upcoming interview, approach it with calm discipline. Study the full 128-question bank thoroughly. Rehearse aloud. Organize documentation in labeled folders. Review your travel history carefully. Bring certified tax transcripts. Ensure consistency across all forms previously filed with USCIS. Anxiety thrives in uncertainty. Preparation eliminates uncertainty. As immigration policy continues evolving in 2026, staying informed is critical. Executive actions, USCIS policy manual updates, and procedural memos can influence adjudication standards quickly. Monitoring official updates ensures that you are not relying on outdated information. Your American dream remains achievable. But in March 2026, the path to citizenship requires more diligence, more documentation, and more awareness than at any point in recent years. Citizenship is not being denied broadly. It is being examined more closely. If you approach your application with transparency, organization, and thorough preparation, you can navigate this environment successfully. Thank you for joining this extended March 2026 Immigration Masterclass. We will continue to monitor developments closely and provide timely updates so you remain ahead of every change. Stay prepared, stay informed, and we will see you in the next briefing.